Call today is People Against Aceval. Justice Corrigan has recused herself from this case. Good afternoon.
May it please the Court, good afternoon. I'm David Moffitt on behalf of Defendant Appellant Alexander Aceval. I'd like to reserve 4 minutes for rebuttal unless the Court has additional questions that go over. This is a case, I believe, of first impression and of great moment to the jurisprudence of this country. At stake is whether a judge, a prosecutor, and police can act in concert to commit crimes to achieve a conviction and to subvert the jury deadlock mistrial system to attempt to defeat jeopardy, and as part of the original misconduct, to secure the retrial of the defendant again until they all but torture his submission to conviction by exhaustion of his resources, denial of his right to counsel, obstructing justice by a prosecutorial conflict of interest in not prosecuting its own first trial witnesses before proceeding in the second trial, including the judge as a witness in that second trial, and by generally withholding evidence that would have further demonstrated the extent of that continuing conspiracy from the second trial. I think the public and the bar deserve a full examination of the circumstances, and I heard in a previous oral argument why something deserves a full examination of the circumstances. It is because this is a case of public corruption that I believe touches the honor of every police officer, judge, and prosecutor in this state. We would not be satisfied if we had merely been told, well, even a fifth grader knows that this is perjury. We would want to know what and why do you say so, and what was the perjury, and how do you conclude that that actor committed that perjury. We would want a discussion of every detail because the public deserves that, because this is their government. And I would note that the Court of Appeals opinion is replete with assumptions such as the jury was hung. Ask me about that. This jury was not hung. A jury is not hung in the sense of double jeopardy analysis if it is lied to dozens, perhaps hundreds of times, and a corrupt judge, to conceal their own part in that perjury scheme, puts their heavy hand on that decision and violates every provision of double jeopardy law to corruptly declare a mistrial, to conceal her own complicity in it. That is why the public needs to hear every detail of this case, and that this application should be granted. If there are questions.
Other questions? I have none at this time, sir.
Thank you. I'll reserve the remainder of my time.
All right.
Jason Williams, Assistant Prosecuting Attorney from Wayne County for the people, the appellee in this matter. I have a few brief opening remarks and then we can get to your questions. The issue in this case is not whether a prosecutor engaged in misconduct. She did. It was egregious misconduct. She knowingly used perjured testimony. The issue is instead whether Mr. Aceval, who has now pleaded guilty in this case, goes unpunished. Due process is the constitutional provision that is violated when the prosecutor uses perjured testimony. It's the defendant's right to a fair trial. It's his right to procedural due process. And the purpose of Mooney v. Holohan, as well as the court's Brady v. Maryland jurisprudence, is to avoid an unfair trial. Those cases don't call for the punishment of society for the misdeeds of a prosecutor. And with the exception of claims of insufficiency of the evidence, a retrial is the remedy for the due process violation. And that remedy is justified by society's interest in punishing one whose guilt is clear. Mr. Aceval could and actually was receiving a fair retrial when he elected to plead guilty after his own efforts to support perjury came to light. The Court of Appeals correctly held that dismissal was not the remedy for the due process violation and affirmed that conviction. There's no reason for the court to disagree with the Court of Appeals. For that reason, we ask that the court simply deny leave to appeal. Happy to address any questions the court may have.
There are no questions, sir. Thank you. Mr. Moffitt, do you wish to rebut?
Thank you, Your Honor. Mr. Aceval will not go unpunished. He is not here today. That's because he's in prison, and he's been in prison for 5 years. He is by far from unpunished in this case, and perhaps he faces the possibility of further proceedings, further retrial, further expense, and all those things that are addressed in the double jeopardy standards for why subsequent retrial should not go forward. It has been said by the prosecutor's office that he received a fair retrial. I am pleased that they made that assertion because that puts the second trial directly into issue here. That second trial was corrupt, and I have filed a motion to supplement this record that included the Attorney Grievance Commission statements of certain parties in this matter and investigatory interviews by the Attorney General's office that I believe would further document that that pretrial was plainly, additionally perjured. I have submitted the investigatory retrial interview of Mr. Povich, the confidential informant here, where he stated that where he clearly, when he was given immunity by the Attorney General's office, contradicted the statements he made in the second trial. There was obstruction of justice in conducting the second trial completely. Judge Waterstone was allowed to come in, a sitting judge, still in the same circuit where the case is being tried, which clearly enhances the prestige and believability of the prosecution witnesses.
Your view is the Court of Appeals erred in that we would err if we were to apply a but-for analysis to this case in trying to ascertain how things would have been different, if at all, if there hadn't been the misconduct on the part of the prosecutor in court. Is that right? We should look merely at whether or not there was outrageous behavior, or at least behavior that violated the Due Process Clause.
I would submit that that would be sufficient to reverse and bar a second conviction, but if they intend to assert that a second trial was appropriate, I would ask that that motion be granted, that that additional material where Judge Waterstone states that she deliberately granted a mistrial with the intent of avoiding jeopardy so Mr. Aceval would be unpunished, would be admitted to show that they deliberately intended to defeat his due process rights, which the Court of Appeals freely admits. I will contend, if you wish, to keep my arguments to the first trial, and I will submit that you cannot. It is a gross perversion of the law of our state to claim that a trial judge who has a clear interest in attempting to conceal her own complicity in the perjury scheme by not correcting the perjury that was implicit throughout the trial, which she personally deliberately protected, and accordingly declares a mistrial to conceal her part in that, to call that receiving a remedy, a fair trial.
I'm kind of new to this controversy.
And it's a pleasure to appear before you, Justice Davis.
And won't be around it long. But what's the remedy that you seek here? What do you want?
Vacation of the conviction and barring of retrial.
He pled guilty.
He did?
Yeah.
Yes, he pled guilty in a second trial that was still being protected by the first trial judge. This honorable court, with the exception of 2 present members, actually let pass without review the fact that Judge Waterstone ordered that there can be no defense expert witnesses, that that second trial would be conducted without being allowed to ask questions that tended to elicit perjury from the prosecution witnesses.
What about defendant's claim that he was denied his counsel of choice?
I think it is equally important to review this case because of the violence it has done to to a defendant having a choice of Sixth Amendment choice of counsel and right to present a defense. In this case, 12 days before trial, I was there. I was ejected on a peculiar and bizarre diatribe that I think would go reviewed just for the terms used by that jurist alone if the roles and races were reversed.
You weren't going to be the trial attorney, right?
I'm sorry, Your Honor?
You weren't going to be the trial attorney, right?
I was not going to be the
He had
trial
the trial
attorney.
attorney of his choice,
That's
though.
right.
Okay. Couldn't he have objected to your dismissal?
He wasn't allowed to speak, and they took him away, Your Honor. He had written a letter that said, I need both of you. I actually wrote that letter, and I submitted it that day in accordance with instructions from him that said, I need both of you to win. This trial had 140 hours of tapes that the defense counsel, trial counsel, hadn't even listened to yet, much less appellate counsel. I mean, I'm trying to write motions to achieve this interlocutory reversal. That was still pending on rehearing when I was ejected. The other counsel's role was completely different, cross-examinations, opening statements. I could not possibly have become the trial counsel 12 days before trial, and the judge said she's not going to allow anybody else to come in here. And I would also note, she got this trial after March 28th of 2006. The trial occurred on June 5th. She didn't even have this case 90 days before she insisted her trial docket outweighed the right to counsel of choice. I don't think it does under those circumstances.
Do you agree that the defendant can be retried because the perjured testimony was to protect the confidential informant's identity and not to avoid an acquittal by the prosecutor?
That's a theory that the prosecution abandoned 2 appeals ago because there is no evidence to support it. And I would not agree that there is an exception in the Constitution for the subjective thinking of a county jurist to the Constitution that would allow such a circumstance.
Let me ask you a question. Why would it not be fair to set aside his plea even, as much as I'm generally of a view that when somebody pleads, that's it. But under the circumstances existent, as I'm understanding, set aside the plea and give the man another trial. Why isn't that fair?
Well, as I've indicated in one brief, and I filed perhaps 7 in this matter, there is a policy against trying cases on recanted testimony, a policy which I think has been well-founded in this court. But to go back to the central issues of this case, I believe that that would implicitly allow, that's based on calling this a mistrial, a hung jury mistrial. You cannot lie to a jury and say that they are hung.
I don't know about recanted testimony and all that. What I'm talking about is you smooth out the sand in the sandbox. You put this case someplace where the well's not been poisoned by the publicity. You get a good judge, and you try the case. And all the stuff that ought not to have been there isn't there. And he goes to trial just simply on the right evidence, what they got.
Because we can't give the prosecution innumerable bites to cheat and cheat again and yet cheat again until they get the man convicted, which is exactly what happened here. It is a policy that this court cannot endorse. This court similarly cannot excuse the pretext for that policy, which was that this was a hung jury mistrial. This was a lied to jury mistrial. This was
That's why he was being retried when he pled guilty. That was already corrected by him having a second trial.
It is never corrected.
It was during the second trial that he pled guilty, right?
I'm sorry?
Isn't that right? It was during the second trial that he pled guilty.
It is not a remedy, a so-called fair treatment of a defendant to afford him a second trial, whether it was crooked or not, and it was.
But he never argued that before.
Pardon me?
He never argued that before.
His attorney was kicked out of the trial.
Do I understand that would a better argument arguably be that if this information had been discovered before the conclusion of the trial, as opposed to being discovered well after the trial had occurred, there would have been a dismissal, probably under our double jeopardy doctrine, with no opportunity for a retrial.
I think it's a great argument, and it goes ever to the strength of that argument that the prosecution and the judge combined to conceal that coming forth.
Well, I'm not sure I'm asserting that argument so much as asking about it.
I think it's a fine argument, Your Honor. Bless you.
Are there other questions? Thank you, Mr. Moffitt.
Thank you for this opportunity.
That concludes our oral argument today. We're in recess until 9:30 tomorrow morning.